Hello everyone, welcome to this recording. It is a lovely sunny afternoon here in France. First of all, many thanks to your professor, Philippe Dorsemont, for the invitation. Normally I would have been with you in person, but of course, as most of you, I'm sure I am here in lockdown at my place. So today I am gonna talk, hopefully not for too long, about the EU economic governance and its impact on labor law. As such, I will have to deal with topics that, in general, you will not consider as immediately pertaining to labor law in a strict sense, but I hope that by the end you will have a clearer idea about why this topic is relevant and why you should be concerned with this topic if you are interested in labor law or social security law in general. Before I begin, let me just say that I hope that you're all safe, as well as your families and loved ones, and that you are staying safe at home. Further, well, I am an Italian working in France, so I am as far removed from the English language as it is humanly possible. So I hope that everything will be clear and understandable. If you have any questions, please feel free to drop me a line. I will put my contacts at the end of this presentation. Or I'm sure Professor Dorsemont can give them to you. Also, feel free to write me if you are curious about anything I will present in this slide, or if you want to know more about any of this. Right, so let's start. You have had enough time to digest the menu for today. So I will start from the beginning, which is also the end in a way, because our story, as many stories go, starts with a crisis. Not the present one we are living, but the old one, which for some of you might be already too far in the past to remember. Don't even tell me how young you are, it will just make me feel old. So I am talking, of course, of the economic crisis started in 2007 in the US with the bankruptcy of Lehman Brothers, an investment bank, and then continued in Europe for a few years more and called then the Eurozone crisis, the Euro crisis, and so on. So I hope you have a basic understanding of what happened in the context of this crisis. If you don't remember what happened, or if you want to know more, I have put some suggestions for readings in the slide notes. Of course, I mean, so much to read. No, there's no obligation, but it's kind of an historical event. And again, if you have any interest on labor law or labor policies or social policy, this is a major event for the history of social policy in Europe. So I encourage you to read more about this. Okay, so I will take it all for granted, the knowledge of more or less what happened. I will only mention the parts which are relevant for the present presentation. All right, hope this is not too much to take for granted, but bear with me while I try to keep it short-ish, okay? So during the crisis, a certain number of European countries found themselves in a difficult financial position. And this was due to a large extent to several limitations of the Eurozone. And in particular, these limitations, I try to summarize in the slide, meant that it was not possible to bail out these countries, meaning other countries could not provide direct financial assistance. This is provided by the Treaty on the Functioning of the European Union, Article 125. Second, the European Central Bank could not work as other central banks, as most other central banks. So it could not provide direct financing to European countries. So it was not possible for the European Central Bank to buy national debt, national obligations and bonds. Third, since the euro area had one exchange rate, since they all used the euro, it was not possible for the exchange rate to fluctuate between countries, which meant that although a country was experiencing a shock and as such exporting, for instance, less, had a fall in production, etc., etc., the exchange rate vis-a-vis the other European countries would not change. Okay. So this instrument, this economic instrument, was also not available. And fourth, it was not possible to counter this crisis with, let's say, classical policies, which meant investment from the public sector. This will be familiar to you in the present days, because many countries around the world, you see now with the present coronavirus crisis, you see countries that want to put money in the economy by, for instance, providing further unemployment protection or direct investment and so on and so forth. So this kind of policies was made very difficult in that context because of fiscal rules of the Eurozone that provided for limits on how much deficit a country could run, and in theory also how much public debt a country could accumulate. So in this situation, with all these limitations, the European answer to the crisis, starting in 2010 in particular, from the moment, if you remember the story, that a new Greek government, a center-left government, came to power and discovered that previous government had, let's say, been kind of creative with accounts, or so the story goes. If you want to know more, please, I encourage you to read what I suggested, and that the deficit was actually much higher. This created a spiraling panic in the market, lack of confidence in the possibility for this country to pay back their debt, and considering the limitations I just listed, investors considered there was no so-called lender of last resort, so someone which could step in if a country was like Greece or Italy or Spain or Portugal or Ireland would be experiencing a difficulty in repaying the debt. So this caused a sort of panic, which made the situation more difficult for these countries, and no one could come to the rescue. So the European response to the crisis, starting in 2010, revolved around two main ideas. Let's say the broader one, and a specific one for labor policies. The broader one, you know the word, was austerity. The narrative went this way. So these countries have spent too much in the past, so now they have to cut. Okay, they have to spend less, cut public services, cut expenditure, and so on. This is what has been now called austerity policies. This meant, for instance, freezing wage increases for public sector, stopping hiring new people in the public sector, or outright reducing the size of public sector, which meant less social services, less social security, and so on and so forth. For instance, this meant cut in healthcare, which, these days it's a less popular choice, I would say. For what it matters for us, these translated into labor policies aimed at what's called internal devaluation, which means, to make a very long story short, decreasing the relative cost of labor compared to competitors. So, for instance, Italy cannot change its exchange rate compared to Austria, Germany, the Netherlands. What they can do is to compress the wages of the workers so that in the end their products are more competitive in the market. How do you achieve that, of course, is the objective of policies aimed at internal devaluation. You can freeze wage increases make it more difficult for collective bargaining to increase wages, make it easier to fire workers so that you give more power to employers, and so on and so forth. So this was the policy to regain competitiveness on the market, internal devaluation. This was the objective. Those two tools, reduce expenditure by cutting public expenditure and regain competitiveness by reducing wages and labor costs, were the two objectives of the European EU answer to the crisis. In this context, a number of countries ultimately needed financial assistance, which was provided often outside the EU structure to circumvent these limitations that we just saw. And keep this in mind because it will be relevant in legal terms in a moment. So these countries which received financial assistance in the form of loan, so no money was given without the promise of repaying it. So those were loans, but still, even though there was an obligation to repay them, countries which received financial assistance had to sign what's called memoranda of understanding. These memoranda were an agreement between the country receiving financial assistance and the Troika, which was formed by, you should know that, the International Monetary Fund, the European Central Bank, and the European Commission. So these memoranda, for what matters for us, included a set of conditionalities. You can see here an academic definition of conditionalities. It means, in very short, things that the country will have to do to get the financial assistance. Okay, promises that you make in exchange for loans. Further to these memoranda, other countries like Italy or Spain received secret letters from the European Central Bank that asked again for reforms in exchange of its assistance on the financial markets. The content of these letters is actually known because, yeah, so much for secret. One of those was published in Italian national newspaper. So we know that the reforms requested were very much in line with the rest of the memoranda, and we will see in a moment what the content of these was. So the content of memoranda, for what is interesting for us, so looking at labor and employment policy, focused very much on these topics. Here you can see from a study of 2014, the reference is in the slide notes, an analysis which is based on the weight of employment-related terms in the actual text of the memorandum. So how often employment and labor are mentioned in these documents. And here you can see, basically, if you want to interpret T plus 1, T plus 2, T plus 3 means the year of the memorandum, the second year of the memorandum, third year of the memorandum, and the fourth year of the memorandum. And the other axis means how often per page labor and employment are mentioned. Of course, 0.1 means that every 10 page there is something about labor, 0.2 means that every 5 page there is something about labor, and so on and so forth. So labor and employment were very much present in the memoranda of understanding, focusing in particular in a few areas. The first one is the broader area of social protection, including everything from retirement to unemployment insurance to even healthcare, and with a clear, it will not be a surprise, with a clear objective of reducing expenditure for social protection. The second important area of intervention was dismissal, whether individual or collective, depending on the countries. And in general, the idea was to make it easier to fire people. Again, always think in terms of internal devaluation in order to make it easier to lower wages, to give more power to employers. And the third, very important area of intervention is collective bargaining. And here, the intervention was meant in general to reduce the coverage of collective bargaining, to switch the focus from sectoral collective bargaining, so where collective agreements cover an entire sector of the economy, to company-based collective bargaining. Or, more in general, to freeze collective bargaining, to freeze increases of wages, to make it harder to negotiate collective bargaining or to extend them to a whole sector. This was the policy, this was the objective, and in many cases it was successful, as we will see in a moment. So a few examples of what was demanded from the main example during the crisis, Greece. For instance, it was asked from the Troika to Greece to reform collective bargaining, to increase the importance of company level against the sectoral level, and to stop the so-called after effect of collective agreements. What does it mean? It means that you have a collective agreement, for instance, for 3 years, and the Greek legal framework for collective bargaining said that if after 3 years you do not negotiate a new agreement, then the old one would keep on being in force, being legally applicable. The reform, which was introduced and adopted, said that if after a certain amount of time a collective agreement ends and you cannot negotiate a new one, then no collective agreement is applicable and you go back to the legal minimum wage. Okay? Which of course provides a strong incentive for employers not to sign a new collective agreement. You might say, well, maybe that was the objective. I will show you a few numbers in the second part of our presentation, and you will see there has been, no surprise, a huge drop of sectoral collective agreement in Greece during the crisis. The second point is very straightforward: reduce minimum wage, reduce pay for overtime, reduce minimum wage specifically for younger workers, because of course youth unemployment was a huge problem in Greece during the crisis. It still is, don't worry. And of course, how do you tackle youth unemployment? Well, it's easy. You pay young workers less because the theory goes then employers will hire them more often. Third point is the reduction in severance pay, so make it cheaper to fire workers and increase the use of temporary contracts. So again, increase the so-called flexibility of employment. The interesting thing about memoranda, although probably it's not a surprise because you would also comply with what it's asked from you if you were to have a gun pointed at your head, financial gun pointed at your head. The level of compliance with memoranda was very, very high. And this, although the narrative during the crisis was about the southern countries, Greece in particular, but also Spain, Italy, Portugal, not doing what they had to do, this is not actually true. If you look at the document from the European Commission analyzing the compliance with the Memorandum of Understanding, they were actually being complied with, meaning the countries were actually doing what the conditionalities asked. In some occasions, in particular from the Greek second memorandum, many of these conditionalities were included prior to disbursement, meaning that the country had to introduce the reform first in order to get the money. So you don't get the money as long as you don't introduce a reform. Okay? So there were scenes in national parliaments where parliaments were approving huge reforms of labor law or social security before midnight, because otherwise the creditor would not pay the money. Okay, so this was the situation. Compliance was indeed very high. And compliance was also very high if compared to national traditions in terms of complying with EU law. Many of these countries, in prior studies, in particular a very important study from 2005 by Gerda Faulkner and a group of researchers, considered some of these countries of so-called southern periphery of Europe, Greece, Portugal, Spain, Italy, as reluctant in complying with EU directive, meaning they took a lot of time to transpose EU directives. This was not the case for EU memoranda, so it was a path-breaking moment in the history of the relationship with the EU. The second interesting thing is that the changes introduced with memoranda proved to be very resistant to political change. So even when a government of a different color were to come into power and the memorandum had finished, still the structural reforms introduced under the memorandum, MOU is the acronym, remained in place. So it was not politically feasible to change them. The minor things introduced with memoranda were sometimes more or less changed. A recent study considers that more or less 50% of the measures introduced with the memoranda, the minor ones in particular, were changed after the end of the memoranda. But the more important ones, the structural reforms, particularly, for instance, in the context of collective bargaining or social protection, for instance, retirement reforms, remained in place. As such, these instruments proved to be very powerful, so maybe also, of course, because the situation was quite desperate and these countries had apparently considered to have no other option than to comply with the memorandum, were a very powerful instrument to foster change in EU member states, from EU institutions, by EU institutions, and there were, and this keep this in mind, it will come back with our conclusions, more effective than classical EU law instruments like directive. Now, you might ask, why are we studying this? It's always a very legitimate question. Why are you telling all this? The crisis is over. There are no more memoranda of understanding out there. Everything is fine. Yes, more or less, that crisis is indeed over. But this kind of tools is by no means disappeared by the European debate. First, because the so-called 5 Presidents report of 2005, the 5 presidents being presidents of EU institutions, the 5 Presidents report invoked many times the use of financial instruments to sanction and control reform implementation in member states, so providing the same rationale as memoranda of understanding. And second, because the document redacted by the French and German government in 2018, the French-German roadmap for the euro area, also calls for the use of conditionalities and sanction to ensure that member states comply with reforms that are needed, of course, from the point of view of certain political area and certain European institutions, but still. So the idea of memoranda and of conditionality is still very much with us. And the second, to show you to which point this is with us, that there is a debate going on right now in the context of the coronavirus emergency. We all know that countries are spending a huge amount of money and there will be a very large economic crisis after the coronavirus epidemic because of the cost of, in a very basic terms, locking down most of the population and closing companies and so on, which, let me just say, are the correct answers to the situation, and they should be put in place. So there will be economic consequences. And some countries, quite a lot of them actually, in the euro area have asked for a collective answer to this economic situation with the emission, in particular, of collective debt, European debt instrument, so-called in the newspaper debate, Corona bond, of course. Iron bond, Corona bond. Anyway, so to this, certain countries, in particular the Netherlands has been the most vocal opponent, but also Germany, Austria and Finland were in this side, considered that no, economic help, financial assistance from the EU should always come with conditionalities. So this should not be a new debt as that, just as simple as that. No, we should have the same thing as during the financial crisis, so memoranda of understanding and conditions to get financial assistance, right? So as you can see, the same instruments are still there, so it's quite important, if you are interested in labor law in whatever aspect, legal, political, research, legal practice, everything, these instruments have drastically changed the face of labor law and of social security in the countries which were under memoranda of understanding during the crisis. So if you're interested in these topics, you should consider what memoranda are and what's inside them. What's the, let's say, general policy direction enforced by memoranda. Okay, so far for the context, so good. Now we will go into more legal stuff, of course, because you are asking yourself, am I in the right class? Probably, hopefully. So in this part, I will focus on some decisions from the Court of Justice during the crisis, and also a few decisions from international labor law monitoring bodies, in particular India ILO and the European Council, notably concerning the European Social Charter. As you can see from the title, the Court of Justice has not proven to be able to control measures implemented during the crisis, as I will show you in a moment. However, before going directly into the measures related to fundamental rights, for instance, I will say a few words about two very important decisions for the European economic governance. The first one is the decision in Pringle. All the references to the case law are in the slide notes. Don't worry, the slides will be on Moodle or whatever digital platform you use now at UC Louvain. The first decision is Pringle. Pringle deals with the creation of the European Stability Mechanism. Again, I don't want to go into much details, but as I told you, at a certain point of the crisis, there was some financial assistance provided to some member states under memoranda of understanding and with conditionality, but still there was some financial assistance. And how to do it, circumventing the treaty, was the legal question. And this was done by creating specific instruments under first international law and then EU law itself. So someone, in this case in Ireland, at a certain point came up and asked, is this compatible with Article 125 of the Treaty on the Functioning of the European Union, which forbids so-called bailouts, so financial assistance from other member states or from the EU itself to a member state. So the Court of Justice said, yes, this is allowed by the treaties, but as long as member states remain subject to the logic of the market when they enter into debt. As such, as an author wrote, assistance is only possible if it is ineffective. Or, to put it in his own words, disaster can only be avoided if disaster is a credible prospect. So you can only provide financial assistance as long as it's not too helpful, and the member states should be left a little bit or a lot to deal with the market, with financial investors. Okay. So the Court of Justice said, yes, you can provide financial assistance. Still, the countries should be left to face the market. You cannot help them too much. And what is more important for us, very important, conditions are necessary to be compatible with the treaty. So with this decision, the Court of Justice constitutionalized conditionalities. In the reasoning of the Court of Justice, it is the treaty itself, the Treaty on the Functioning of the European Union, that requires conditionalities to be attached to whatever financial assistance might be provided to a member state during a crisis. This is, of course, relevant also to the debate about the coronavirus financial assistance, but let's not deal again with that. Okay, so this was the Pringle decision, constitutionalizing conditionalities. The second decision is Gauweiler, and in this case, it was addressing the intervention by the European Central Bank. Some of you might know, and if you don't, you should read about this, that at the peak of the crisis in 2012, very hot summer, the European Central Bank President, Mario Draghi, intervened in a speech to say that the European Central Bank was ready to do whatever it takes, this is the historical part, whatever it takes to preserve the euro. Okay. And whatever it takes, it meant that in practice, the bank then created a mechanism to intervene buying the debt of member states, not directly, and this was the legal tinkering, not directly, but in the so-called secondary market. I don't want to go into too much details here, also because probably someone else is more qualified than I am, but secondary market means in a very short that the bank cannot buy debt when the state creates it, when the state wants to sell its bond on the financial market. The central bank cannot directly buy it, but the central bank can buy it when the investor who has originally bought it wants to sell it. Okay. So it's not as effective as buying it directly, but of course it means that everyone buying this debt knows that when he or she wants to sell it, probably the central bank will be there to buy it. And this very intervention was sufficient to signal to the market that the European Central Bank wanted to function as a normal central bank and circumvent the limitation of the treaties. And this calmed investors on the market to a very large extent, more than whatever structural reform was demanded by memoranda of understanding, right? However, this was also subject to a challenge by a series of German actors in front first of the German Constitutional Court, which then sent a preliminary question to the Court of Justice of the European Union. This was, of course, a very delicate decision, because deciding that the central bank could not do it would have by itself reignited the panic on the market. So no surprise in discovering that ultimately the Court of Justice decided that yes, these mechanism, the outright monetary transaction mechanism, OMT, as you can see in the slide, was indeed compatible with the treaty. What a surprise. But, and this is again a little difficult thing to understand, it was legal as long as it has it doesn't have an equivalent effect of direct purchase of government bonds, so in the primary market. How to distinguish it? Good luck, but for the moment this was enough, and the European Central Bank could go on with its mechanism to stabilize the financial market and interest rates paid by countries to finance themselves through debt. Okay, so these two challenges were ultimately defeated in front of the Court of Justice, but they also meant that conditionalities were now necessary for these kind of interventions. And also, the OMT program of the central bank could only be used in the context of financial stabilization programs too. So in a way, again, this constitutionalized the functioning of the economic governance through memorandum of understanding and conditionalities for countries in need of financial assistance. Coming now to the protection of fundamental rights, if you have been paying attention, and I really hope you have, some measures contained in the Memoranda of Understanding were liable to have an impact on fundamental rights protected by the EU legal order. So at a certain moment, actors at national level tried to use this to protect people from the impact of the Memorandum of Understanding. So there was a preliminary question from a tribunal in Portugal, particularly from Porto, which asked the Court of Justice if national measures adopted to implement a memorandum of understanding were covered by the EU Charter of Fundamental Rights. You know perfectly that the Charter applies when EU law applies, okay? When you are in the scope of EU law. So the question essentially was, are memorandum of understanding EU law, so that all measures taken by a national government to implement the memorandum, which requires from them reforms, should comply with the EU Charter of Fundamental Rights. And the answer of the court was no, they are not EU law, they are international agreement, and although they are signed with the EU Commission, with the European Central Bank, are monitored by the European Commission, and so on and so forth, they are not EU law. Okay. You will see in a moment this is not true for all memoranda, it depends on the legal basis, but in the case of Portugal, this was the case. So the financial assistance was provided outside the EU system, a new facility, legal body was created, but outside the EU legal order through international treaties and agreement between member states outside the EU. Although it used EU expertise, the EU Commission was involved and so on and so forth, said the court, oh no, this is an international agreement. This is not EU law, so the Charter does not apply. And this was also, you will see it in also quoted in the slide notes, repeated by a commissioner at the time, Irki Katainen, who said the memorandum of understanding are not EU law. Right. So just like that, all of that was excluded from the Charter of Fundamental Rights. Quite easy. You can start seeing why the title of this section. Second attempt was to invoke the liability in tort of the European Commission for losses caused by memorandum of understanding, in particular in Cyprus. Here it needs a little bit of explanation. The memorandum of understanding for Cyprus was directed in particular to the banking sector. And it meant, to make again a very long story short, that people who had money in the banks of Cyprus lost some part of their savings, in particular if they had above 100,000 euros. So this was for them very clearly an economic loss, and it was caused by the measures required by the memorandum. So the question is, can they invoke the liability of the Commission, and in particular based on Article 17 of the EU Charter of Fundamental Rights, which protects private property. And the Court of Justice said yes, because although memoranda are not EU law, the Commission, when it acts, it still has to respect the EU Charter of Fundamental Rights, which is in a way the very constitution of the Commission itself. So they have to respect the Charter. So a restriction of a right provided by the Charter can indeed entail the tort liability of the Commission. However, of course, a restriction of fundamental rights, you probably know it already, can be justified under a test of proportionality. And the Court of Justice considered that this restriction was indeed proportionate. And this was relatively easy because of the general interest that the Court of Justice considered it was being protected by this measure. So it's called a bail-in, the fact that people who have money in the bank themselves will finance the saving the bank, so they will lose money themselves, a bail-in instead of bail-out when money comes from outside. Okay, so they lost money, but this was okay because there was a non-objective, legitimate objective. You know the steps of proportionality test. So legitimate objective, necessity, and then not go beyond what is necessary for the achievement of the objective. And the Court of Justice said, well, the objective was ensuring the stability of the banking system of the whole euro area. So, of course, in front such an important objective of saving the whole financial system of Europe, well, what does it matter if you lose a certain amount of money? Okay, so the choice of the objective from the Court of Justice made it essentially impossible to prove that a restriction to a fundamental right, which in this case was the right to private property, was disproportionate. Okay, because yeah, your right to private property against the stability of the banking system of the euro area, well, it's easy to have a proportionate measure in this case. And this will play again a role in a more recent decision. This is Florescu, Romanian decision, because also Romania, before all the others essentially, had signed a memorandum of understanding, and it was, of course, in financial difficulty. So again, the question was, is the memorandum of understanding EU law? And in this case, the decision of the court is different, because this memorandum is based on a decision from the Council, and as such is based on an act of the EU. So yes, this is EU law. This decision came in 2017. And it took a very long time for the Court of Justice to decide this, around 3 years. This means that when it was decided, there were no more memoranda of understanding. Oh no, yes, there was still one memorandum of understanding ongoing, the third memorandum with Greece. But for the rest, they all had ended. And in a way, the whole narrative of the crisis was gradually disappearing. And in the end, this casts somewhat of a doubt about the ability of the Court of Justice to protect fundamental rights during a crisis, because no decision about a memoranda and about its impact on fundamental rights was taken by the Court of Justice during the crisis itself. Anyway, so in this case, the question was a person whose pension had been cut because of a measure introduced by the Memorandum of Understanding. I will not go into details. The case is quite specific, and probably the person itself had a sufficiently high pension anyway. In any case, the pension was cut. So again, the person invoked the right to private property, also on the basis of the case law of the European Court of Human Rights, which I cannot explain now, which protects pension claims under the right to private property. So there was again a restriction to a fundamental right, the right to private property. But the Court of Justice considered that the objective of reducing public spending, so cutting pensions, was in itself an objective of general interest. And then, since this reduction of public spending was needed to avoid a financial crisis, then the restriction was indeed proportionate. And it is telling in this sense that the Advocate General, in his opinion, it was Advocate General Bott, in his opinion, said, let's say, somewhat unfortunate choice of word. He said, and I quote, "It does not seem open to debate that the objective of meeting obligation resulting from the Memorandum of Understanding is an objective of general interest." End of quote. It's in the slide notes. So, respecting the memorandum in itself is an objective of general interest. So, every restriction to a fundamental right under a Memorandum of Understanding, following this reasoning, already starts with a justified objective, which is respecting the memorandum, kind of circular, okay? So maybe it will be disproportionate, maybe it will be too much, maybe it won't be necessary to respect the memorandum, but there is an objective of general interest. Also, particularly telling in this decision, because the number of people covered by this specific measure, cutting the pension, was very limited. And it was not requested specifically by the memorandum. So, yeah, the amount of money saved by this was very low, and it was not requested. So how this can be construed as respecting the memorandum is, yeah, kind of stretching it. But still, this was the decision of the court. So cutting public expenditure is an objective of general interest in itself. It doesn't matter what you do, why, etc. Is it necessary or not? Is it a lot of money or not? It's a general interest. It's an objective of general interest. So it's you can see it's very easy, or it is easier at least, to justify restriction of fundamental rights under Memoranda of Understanding. So now a few insights from other legal orders. The ILO in particular the International Labour Organization, but I'm sure you know everything about it, sent a high-level mission to Greece to assess the impact of the first memorandum, and, no surprise, it found several violations of ILO conventions, in particular for what is important for us in the field of collective bargaining. And the same went for, in general, the approach of the Troika, which, as you can see, rarely considered the employment objectives in its discussion with Greek government. The same critiques were also expressed by the monitoring bodies, the Committee on the Freedom of Association and the Committee of Experts on the Application of Conventions and Recommendation. Those were in particular again addressed to collective bargaining, because during the crisis Greece had introduced a particularly problematic provision allowing company-level agreements. Remember, to promote company-level bargaining was one of the objectives of the memorandum. So it allowed company-level agreements to be signed not by a trade union, but just by an association of persons, an association of workers. So you don't need a trade union, you just take all your workers and ask them to sign a collective agreement, and it's good. And you can derogate from sectoral agreements, and you can lower wages in particular. And of course, an association of persons does not offer the guarantees of independence and so on from the employer and so on and so forth that trade unions offer. So for this reason, it was heavily criticized by the ILO monitoring bodies, which in particular used some very interesting data about collective bargaining in Greece, showing first a drastic fall of sectoral agreements, which went from 43 in 2008 to 7 in 2012, several sectoral agreements from 48, and company agreements went from 215 to 975 from 2008 to 2012, of which, of 975, 706 was signed by simple association of persons, and the remaining by trade unions. So the interesting point is that of these 706 agreements of company agreements signed by association of persons, 706, 701 have provided for wage cuts. Okay, so 701 agreement out of 706 where workers saying, yes, we want lower wages. Yeah. So the ILO considered that there were problems with the guarantees of independency and, of course, also freedom from pressure from the employer in this situation. So a lot of critiques from the ILO, and also critiques came from several complaints to the European Committee of Social Rights, so the monitoring body of the European Social Charter. In particular, a scheme for apprenticeship for young workers was criticized under a number of articles, but the more interesting is the fact that it provided for a minimum wage which was lower than the normal one, and again lower than the one for younger people, and ultimately was lower than the poverty line. So the European Committee for Social Rights concluded this was against the protection, the right to a fair remuneration, Article 4, Paragraph 1 of the European Social Charter. Second, the possibility of firing someone during the first year of employment without any compensation. So you're fired, no money, nothing, during the first year, was considered to be in violation of Article 4, Paragraph 4, reasonable period of notice for all workers. And finally, the pension reform was criticized here less strongly, just because the government had not considered the impact on poverty of these reform under Article 12, Paragraph 3 of the European Social Charter. So a huge number of critiques from international bodies protecting labor and social rights, but these had absolutely no impact whatsoever on the situation. So the governments did not use, were not able to use these critiques to push back against the memorandum because of the sheer strength of the financial pressure on them. Because of course, oh yes, you can say the Committee of Social Rights said that I should not do this. But if you have to do it to get the money under the memorandum, well, in the end you will choose the more dangerous menace, and in the end choose to respect the memorandum of understanding. So the EU was in its role in the Troika, the European Commission, European Central Bank, was signing off on violation of international labor law and international protection of social rights in these countries during the crisis. Yes, that was the situation. These decisions were seized by the Parliament, the European Parliament, in some reports criticizing some aspects of austerity policy. So they had a role, but mostly a political, let's say, role than a legal one. So our third point deals with a different aspect of European economic governance. So far, we have only considered countries in need of financial assistance, countries covered by memoranda of understanding. What about all the others? Because you might consider, I'm safe, I am in Belgium, why should I be concerned about these lazy Greeks, Italians, Portuguese, Spanish, Irish, Romanians, Cypriots, and so on? Well, long list of lazy people. Huh? Anyway, why should I be concerned? Well, during the crisis, in parallel of all these mechanisms for memorandum of understanding, financial assistance, and so on, the general coordination of economic policies among member states was reinforced with two interventions, the so-called six-pack, 5 regulations, and the directive, and two-pack, 2 regulation. These legal instruments strengthened what is called the European semester. These cover a 6-month period, what a surprise, where member states submit their budget programs and reform programs to the Commission, which then analyzes these programs and adopts country-specific recommendations that are then issued by the Council. Okay, so keep this in mind, this process. If you want to know more, just look up on Google European semester. You will end up on the page of the European Commission, which explains a little bit better all this. I do not, of course, want to drag on for 10 hours this video, so I will just tell you the minimum amount of information right now. So, European semester ends up with country-specific recommendation. This is the relevant part. Okay. Economic surveillance under the economic governance is underpinned by Article 121 and 136 of the Treaty of the Functioning of the European Union. Importantly, to connect with what we said before, countries under a memorandum of understanding do not receive country-specific recommendation. So you can see how the two instruments are in a way similar, just different in strength. So if you are in a very bad situation, you will get a memorandum, otherwise you will get country-specific recommendation, but the objective is essentially the same, okay? Although with different degrees of strength. Don't worry, I'm fine. So these country-specific recommendations are, well, just as I said, policy recommendations. We will see to what extent they are just recommendations, but they are, okay, policies which are requested from member states. In this table, you can see the number of recommendations issued. So these are recommendations for each member state. So you have to divide by member state. This comes from research done at the European Trade Union Institute by Stefan Klauert. The reference is again in the slide notes. So many of these recommendations, roughly a half, depending on the year, are in the social field, in the broader sense, okay? So there is a lot of attention to the social field in these recommendations. To give you an idea of what is included in these recommendation, here I have just taken a table always from Stefan Klauert, just to give the main ideas. Particularly during the years of the crisis, so up to 2014, so under the Barroso II Commission, country-specific recommendation went very much in the same direction of memoranda of understanding. So what we said about memoranda of policy intervention like decentralization of collective bargaining, so going from sectoral to company level, reducing protection against dismissal, and so on and so forth, reducing expenditure for social protection, you can find a very similar approach in country-specific recommendations. Okay, so this during up to 2014, this was the main driver. Afterwards, we see an evolution, a change, so a little bit nicer country-specific recommendation, if you, of course, consider nice to preserve labor rights and social protection. Otherwise, you would have been very happy about memoranda of understanding. So, for instance, you have a greater focus on providing skills, providing social protection for the very poor, so protection against poverty, acting on youth unemployment, and so on. Right. For instance, the youth guarantee, you might have heard of that. So the guarantee that every young person at the end of his or her studies will be granted at least a 6-month internship or 6-month apprenticeship if they do not have already, of course, a job, was enacted also through country-specific recommendations. So there is a change, let's say, in the policy direction, which is quite interesting, starting with the Juncker Commission. And we will see now with the new Commission what they will provide as country-specific recommendations. Those are generally published in June each year. So we will see in this very particular year which kind of country-specific recommendation will be sent to countries. Particularly in the context of retirement, so pension, country-specific recommendation remain very much addressed to the reduction of expenditure throughout the discouraging of early retirement or the raising of retirement age. Okay, so in many cases the Commission requests member states, recommends member states to increase the pension age. To go back to the focus which I already identified of Memoranda of Understanding, under the Barroso II Commission, there was a strong focus on decentralization of collective bargaining, also in the context of country-specific recommendation. In particular, for instance, in case of Belgium, yes, in the case of Belgium, Italy and Spain, these country-specific recommendation asked member state to facilitate, as you can see in the slide, the use of opt-out clauses from sectoral collective agreements, meaning the inclusion of in sectoral collective agreement, let's say the collective agreement for the automobile industry, metalwork, construction industry, to allow company agreements to derogate and impay use, so to have, for instance, a lower minimum wage in the company, or a higher working time, these kind of things. So the Commission requested countries to open up sectoral collective agreements to allow companies to derogate with worse working conditions. And also, second, you can see the other formulation to increase firm level, so company level, collective agreements to better reflect company level productivity and so on. So if you read country-specific recommendation from that time, there was a strong focus on decentralization. Again, because this was considered as an important tool for internal devaluation, so reducing wage costs and improve competitiveness compared to other countries. Of course, when I mention competitiveness compared to other countries, if you are paying attention, and I hope you are, you will see how this is in a way self-defeating, because if Belgium and Italy and Spain do the same thing and reduce their labor costs, since they trade a lot among themselves, they will not get any competitiveness advantage. But that's another story. If you're curious about that, in one of the previous slides, I also included a link to a blog post by Ronald Janssen, which I encourage you to read. The title is Workers of Europe Compete, and that's the very idea of this intervention. So you can see policy directions in country-specific recommendation are very similar to Memoranda of Understanding in at least the first cycle under the Barroso to Commission. Now, of course, you will ask, because you are very smart students, you will ask, why do we care? Huh? Why do we care about recommendations? Come on, Marco. These are recommendations, just ignore them. Okay? They are guidelines, as the pirate code. Why should we respect them? The answer is that yes, they are recommendations, but they might be a little bit more dangerous than just a recommendation, because if a country has an ongoing excessive deficit procedure, meaning they have a deficit which is higher than what is allowed by the treaties of the EU, the respect of country-specific recommendation can be taken into account in the excessive deficit procedure, and the excessive deficit procedure can end up in sanctions up to 0.2% of a country gross domestic product. Okay, so they are recommendations, but they can be taken into account in a process which can lead to sanctions. What is more, if the Commission recommends a sanction against a member state because this country is not respecting the deficit rule, but maybe also because this country is not respecting country-specific recommendation, then the Council, so governments of member states, can stop this sanction only with a qualified majority. This is called reversed qualified majority voting. So you need a qualified majority not to do something, but to stop something. So it reverses the power balance between the Commission and the Council. Okay? So if the Commission comes with a sanction, you only need a few countries to say, yes, we should sanction these lazy Italians, and it's fine. Okay? Take the present debate about what I said, Corona bond. Okay? And again, Italy happens to be the country worst hit by, for the moment, Spain is catching up again, southern periphery. And they propose the emission of this Corona bond to get financial assistance to all countries hit by the coronavirus. And a few countries, as I said, are against it. Germany, Austria, Finland, and the Netherlands, at the moment, what we know from newspapers. So this same block of countries could provide a sufficient majority to say yes to a sanction proposed by a Commission in the context of an excessive deficit procedure. However, this remains for the moment theoretical. No member state has been sanctioned so far under this procedure. The closest it got, it was in 2016 when the Commission proposed a fine of €0 to Spain and Portugal. Still, they proposed a fine, but of €0, more, let's say, moral suasion approach. But still the Council, with a qualified majority, said, no, we don't want even a €0 fine. So for the moment, this remains theoretical, but the possibility, the legal possibility is there for these recommendations to play a role in the context of the excessive deficit procedure. And the possibility of playing a role is not theoretical. We already have examples in the context of labor law. Here is the excessive deficit procedure against Italy, which was closed in 2015. At the time, the economic situation of Italy was not improving. The deficit was not decreasing and the public debt was increasing, actually. And still the Commission closed the excessive deficit procedure by saying, and this is a quote from the document of the Commission, that Italy had introduced reforms which could lead to a positive impact on growth, like the so-called Jobs Act. And the Jobs Act was a reform of labor law which included, no surprise, a reduction in the protection against dismissal. So it made it easier to fire workers in Italy. And this, consider the Commission, oh, this is very good. This will increase the growth in Italy. It didn't. Spoiler alert. But still, so although the data, the numbers of Italy are not improving, we consider this reform will improve it in the future. So we will close the excessive deficit procedure. You can see how this process cannot be a technical process. It is intrinsically a political process of appreciation for some reforms and not for others. Suppose Italy had introduced a reform which increased the protection against dismissal, made it more expensive to fire people for companies. Would the Commission have closed the excessive deficit procedure in the same way or not? And does it have an impact on the nature of country-specific recommendation, the legal nature? We will come back to this in the conclusions, just to confuse you a little bit more. Another reason why these recommendations are not just simple recommendations is that there is increasing reference to the respect of country-specific recommendation as a condition to access to EU funds. Regulation 1303 of 2013, regulating the access to European structural and investment funds, like the European Social Fund, for instance, states that the Commission can request member states to include the respect of country-specific recommendation in the partnership agreement, which is the agreement that they have to sign to receive the money. So to access money from the EU, you have to implement country-specific recommendation, and for some countries, particularly for the eastern periphery, money from these funds is a huge share of their investment each year, up to 60% in some cases. Okay, so if 60% of investment in your country depends on you respecting recommendations, well, you might have a lot of pressure to respect it. Okay, and this is more and more common. Okay, the use of this kind of link between getting the money and respecting country-specific recommendation. So this leads us to our conclusions. Ooh, already? Yes. My objective was 1 hour. It will be a little bit more, but still, more or less. Okay. So conclusions as lawyers and labor lawyers. Faced with this new phenomenon of European economic governance, there are essentially two possible reactions for labor lawyers. And with labor lawyers, I mean everyone who is working with labor law, whether at policy level, whether national actors, trade unions, employers association, academics, of course, but also lawyers and judges. Okay, so you have two possibilities faced with this. The first is to say, well, this system, we can use it. We can, as some authors have written, socialize it. We can use this system to provide good country-specific recommendation. We can recommend states, for instance, to better protect their poor or at-risk groups, minorities, women, migrants. We can recommend them to introduce, basic income or better labor protections. There is nothing in itself that does not allow this. And once we do it, once we capture this mechanism, we will have a very powerful instrument to introduce legal changes at member state level. Okay, so this system can be instrumentalized for the protection of labor rights and social policies. And these authors in particular point out at the greater participation of social actors, for instance, DG Employment at the Commission or trade unions in the context of the European semester. Okay, so it can be used for good. We just need to capture it. Okay, for the moment, maybe the recommendations are not the best, but we could do something good with this instrument. On the other hand, it should be recalled that the European semester remains an economic and budget instrument. Its objective is to ensure fiscal stability and to enforce sound budget policies. As such, all reference to labor rights and social policies are to be read only as tools to improve competitiveness, to improve budgets, and so on and so forth. So sometimes social policies can be a positive, can be represented as a positive economic tool, but this whole system forces you in this framework of budgetary rules and competitiveness. So it is very difficult to introduce positive, again, if you consider positive, the protection of social rights and labor rights. If you don't, it's fine. It's your political choice. But if you do, it is very difficult to introduce this in a procedure which is meant to ensure fiscal so-called stability. Okay, so there is in a way a bias in the whole system towards cutting public expenditure, so cutting social services and reduce labor rights. The other point, talking about actors, is that yes, there is a greater involvement of social actors, but the main actors remain those from the economic area. So in the Commission, DG Economic and Financial Affairs. So country-specific recommendation allow these actors to provide recommendation in areas which were completely outside the portfolio previously, like healthcare, for instance, and pensions. And by the way, there have been country-specific recommendation in the past asking member states to reduce their expenditure on healthcare. And now, yeah, they don't look like great choices from the present perspective. But that's what you get when you approach the social policy only from the point of view of reducing expenditure and balancing budgets. Okay, so this is another problem, another bias. And the third problem is, of course, that you cannot introduce rights through this procedure, social rights. Okay, so you are limited in providing recommendation, but if there is a violation somewhere, you cannot go to the Court of Justice on the basis of a country-specific recommendation. My broader point, which I want to make to conclude this presentation, and it's mainly something that I want you to think about, is about the legal nature of this recommendation. So do they remain recommendations, considering that there are sanctions which are possible if these are not respected, or if you might not get money if you don't respect them? And should we consider them in the context of sources of EU labor law, EU social policy? And here I go back to my subtitle at the very beginning, if you have read it, the displacement of social policy. Displacement meaning that you find social policy in a place where you would not expect to find it. You expect to find social policies in directives, in regulations, and so on, adopted by the EU. But now you find a very important tool for social policy, or a very, very impactful tool like Memorandum of Understanding under financial and fiscal policies. So in a way, this is a call for you, if you want to study labor law, social security law, not to neglect sources which are not classical sources, but they still have a huge impact in this area. And second, if they have an impact in this area, if they are effective, and sometimes they are, sometimes not. It really depends on the country. If you are a country without economic problems, then you can ignore these recommendations. It's no problem. But if you have economic problems, as many countries do now, thanks to the coronavirus situation, then this becomes very effective. And maybe for the Commission, it's easier to have a country-specific recommendation than a directive. And also there is no European Parliament involved. Very easy. They just need the Council. So is this a mutation of sources of EU labor law and EU social policies? Good. So I finished with more questions than answers, of course. This is an area evolving. So if you are curious about this, as I said, please feel free to write me a line. Don't worry, be informal as much as you want. I'm not your professor after all. For the rest, I hope you enjoyed the ride, and I hope you are all safe. Again, thanks to Philippe for the invitation, and thanks to you for the attention. Bye.